Hey y'all, I'm the loud little ducky today, and it's Owens V Echard, and this is Owens' appeal brief. Be prepared because it's got a lot of arguments on things that are not relevant, in my opinion. Court of Appeals, State of Arizona, Division 2, Laura Owens, petitioner and appellant versus Clayton Echard, respondent and appellee, appellant's opening brief, in Maricopa County Superior Court and Gingras's information. Here we have the table of contents. So the statement of case and facts, Laura's pregnancy claims, litigation begins, post-trial developments, statement of issues, arguments, which is a lot about Rule 26, which is dumb because Rule 26 was not a part of the evidentiary hearing and trial, as you want to call it, where everything was decided and judgment was given on certain things. Rule 26 was taken off the table a while back, a few months before the in trial, basically. But he still wants to argue it, even though it wasn't even in play at this time. So that argument to me is null and void and a waste of space and time and oxygen. He, of course, brings up the independent investigation done by the judge, as he says, about the hours of Planned Parenthood being closed on Sunday. He wants to talk about the fees and how much Clayton shouldn't have them, and the judgment was too much, as well as the fact that he thinks that Laura is entitled to her cost and fees. And then we have table of authorities, which basically is just his case citations. And if you want to pause to read or look up any of these, you can. I am going to try to link the document itself into the description box if you just want to read through it there. And again, here, just more of the case citations if you want to pause and look at these. Introduction. This case presents some bizarre, interesting, frightened, and salacious facts. The story involves sex, celebrity, even an alleged fake pregnancy. The cast includes an inexperienced trial judge who apparently broke the law to ensure a victory for famous litigant from a popular TV show. No, that's not what happened here, but, you know, points for drama and pizzazz? At the end of the day, the strange facts of this case are almost irrelevant to the court's task, answering a very simple yes or no question. Do the rules of procedure matter, or can the rules be casually tossed aside when they require an undesirable result? No, that's not what was happening here. Your client is a liar, plain and simple. The rhetorical question answers itself. Of course, the rules adopted by Arizona Supreme Court matter. Like all the other statutes and regulations, procedural rules carry the full force of the law. All judges, all lawyers, and all litigants must follow them, whether they agree with the rules or not. Well, you don't follow certain rules, even though you say you're the rule follower. You don't. Your ethical following of the rules is horrendous. It's undisputed that this did not happen here. The trial court ignored one of the clearest and arguable, the single most important rule in all of civil litigation, the safe harbor provision of Family Law Rule 26, the family court variant of Civil Procedure Rule 11. Rather than applying the safe harbor as the law requires, the trial court transformed it into the proverbial screen door on a submarine, a pointless, useless nullity. The obviousness of this legal error is surpassed only by ease with which this court may correct it, by reversing the lower court's judgment and remanding this case with instructions to dismiss the action with prejudice. Of course, this appeal raises other arguments and issues, but the court need not reach or decide any of them. The trial court's error on law on the first point is full dispositive of the entire appeal. Well, it's not, David, because Rule 26 was taken away. Woodnick was going to go for Rule 26. You came on the case. He said, you know what? I'll withdraw it. It was withdrawn. No more Rule 26. That's not what we're deciding. What we're deciding is, does her behavior deserve sanctions from other rules and sanction abilities? Because I believe it was Rule 25, I believe, one of the points in there that Clayton still had. And so that was going to be decided. Rule 26 was just something they added on their initial request. And so while she can say, okay, we're not going to do parenting time, we're not going to do child support and all of that, and we're not going to obviously figure out who the daddy is, even though she tried to do all that, and it was proven little to no fetal DNA. She can't produce anything to save her life to prove she's pregnant other than a pee stick, which doesn't prove anything. But Rule 26 was no longer on the table, so it has nothing to do with the end result anymore. Because when you withdraw something, you withdraw a motion. That means this is not happening anymore. So we're not doing Rule 26 anymore. Nothing was decided on Rule 26 in the judgment that you are appealing. It wasn't on the table. But there was attorney's costs and fees and some other sanctions that were still on the table that need to be discussed. Because while she may not be pregnant anymore, as she says, there are still things that need to be decided in this case because of a counter suit. So stop it with the Rule 26. I know you're not, but it is a pain that you are not getting this through your head. I'm not a lawyer, and I know this. So just stop. It's ridiculous, and I cannot wait for the response for this, because I'm sure Woodnick is just as tired of hearing about Rule 26 as everybody else is. Going into statement of the case and facts. Most points in this appeal involve legal errors which are subject to de novo review. Although Laura disputes many of the trial court's factual findings, she recognizes this court will generally defer to the trial court's factual findings but review de novo all legal conclusions. McDaniel versus Payson in Arizona 2022 case. Thus, plentiful and egregious factual mistakes, notwithstanding factual errors, are not the primary focus here. With those standards in mind, Laura offers the following background factors for context. A. Laura's pregnancy claim, May 2023. In her establishment petition, ROA 1, and later in her trial testimony, ROA 129, EP 71 through 141, petitioner appellant Laura Owens, Laura, claimed that on May 20th, 2023, she had a brief one-night sexual encounter with respondent appellee Clayton Echard Clayton, ROA 129, EP 72. 11 days later, Laura learned she was pregnant by taking a home pregnancy test, or an HPT. CID, also ROA 127, Petitioner's Exhibit 10, timeline. Laura sought medical confirmation of the pregnancy the next day at Banner Urgent Health Care Facility. Yes, check my patient portal. In Scottsdale. The pregnancy test at Banner Urgent Care was positive. Congratulations for a positive P-stick. Yay! On June 17, 2023, Clayton invited Laura to his home in Scottsdale to discuss the situation. When Laura arrived, Clayton doubtfully of Laura's pregnancy, claim, surprised her with a home pregnancy test, which he insisted she take immediately in front of him. Laura took the test Clayton provided. It was positive. Once again, she peed on a stick and she can get an A on her test there. Great. She is an A+ pregnancy test peer. Let's see, ROA 129, EP 74, ROA 126, EP 5, trial court finding regarding June 17th meeting. Clayton provided a pregnancy test for Laura to take. Both parties agree the test was positive. Emphasis added. Yes, they do agree that the P-stick was positive. But why is what we want to figure out. Why was the P-stick positive? Because it wasn't pregnancy. Clayton later confirmed the positive test in the email entitled Something to Consider, which he sent to Laura a few days later on June 21st, 2023. In that email, Clayton made several omissions about the pregnancy. Even after seeing a positive pregnancy test, I still had doubts in my head. Something was telling me to look deeper into things, so I did, and I came up with a theory that could potentially be realistic. Considering you only performed oral on me and no vaginal penetration occurred, the chances of you being pregnant seem considerably low. Although again, maybe rubbing up against one another allowed a sperm to make its way inside of you, but it's very low probability. Nonetheless, it is one. Okay, so you're putting in your appeal brief that while Owen says they had a one-night stand, sometimes you're calling it a one-night ARPing, you're putting in it, oh, see, he agrees that she could be pregnant from oral. So right here, he is saying, here, let me show you where he says she could be pregnant. But it's about oral, not a one-night stand or ARPing. Like, make it make sense. And if Clayton ARPed her, why would she want to have a relationship and co-parent and do all this with somebody who ARPed you? Can you imagine trying to beg somebody to be in a relationship after they ARPed you? Like, make it make sense. It doesn't. Laura and Clayton discussed the situation over the next several weeks, but could not agree what to do. After another positive HPT on August 1st, Laura filed her establishment petition later the same day. Yeah, let's file it when you're like 8 weeks pregnant. Like, it makes no sense. Litigation begins. After 2 months of unsuccessful private discussions and multiple positive pregnancy tests on August 1st, 2023, Laura filed a petition to establish paternity. On August 21st, 2023, Clayton filed a response denying paternity. From the inception of the case and for months to follow, both parties were pro se. Yes, they were. In September 2023, Laura and Clayton agreed to submit samples for DNA testing through a company called Ravgen. Ravgen representatives later indicated the tests were inconclusive because there was little to no fetal DNA found. Thus, there was insufficient genetic material to establish or exclude Clayton as the father with the 95% certainty requirement. Okay, I'm glad you agree that he cannot be deemed the father. Like, he can't. You can say, oh, he could, but he still could have been. No, he couldn't have been. Nope. Bad news arrived a few weeks later. On October 16, 2023, Laura had a blood test which showed her HCG pregnancy hormone levels were 102. Although this test confirmed Laura was still technically pregnant, the level of 102 was far lower than the normal for a healthy pregnancy at that stage. But yet she miscarried bloody tissue in July. I'm thinking in October, if you have bloody tissue in July, you're not going to still have an HCG test of 102. I think it was just period stuff, which I know is gross, sorry, but I think that's what it was. This indicated Laura had either miscarried or that a miscarriage was inevitable. Testimony from Dr. Medchill. I don't want to hear his Virgin Mary Christmas story. Okay? I don't want to hear it. On November 14, 2023, Laura saw a medical provider at MomDoc, an OBGYN facility. At that time, Laura was given 2 pregnancy tests, both which were negative, confirming her pregnancy had failed and that she was no longer pregnant as of that date. After learning of the miscarriage in mid-November, Laura, who likely Clayton remained pro se, billed nothing further in the case. She pursued no discovery and otherwise had no case-related contact with Clayton. Due to inactivity, on December 4, 2023, the court administrator notified the parties that the action was scheduled for dismissal. After receiving the notice of impending dismissal, Laura filed nothing further and took no action to keep this case active. However, before the case was dismissed, Clayton retained counsel, Greg Woodnick, who appeared and immediately filed pleadings seeking to avoid dismissal. Yeah. So he didn't countersue. He was just filing pleadings and motions and things like that. So this is first on December 12, 2023, Mr. Woodnick filed a motion for leave to amend Clayton's response to the original petition. Next, December 13, Mr. Woodnick filed an expedited motion to extend the dismissal date and request for an evidentiary hearing, which is what they had. They didn't really have a trial. They just had a hearing. Just days later, on December 22, 2023, Laura retained counsel for her own. 6 days later, on December 28, 2023, Laura moved to dismiss her petition with prejudice, explaining petitioner is now not pregnant with respondent's children. Here, there is no paternity or maternity to establish, as petitioner is no longer pregnant. Yet maybe do that prior to 2 months after you find out. Just saying. Here, there is no paternity or maternity to establish, as petitioner is no longer pregnant. Accordingly, this case must be dismissed. And he says, emphasis added. On January 3rd, 2024, after Laura moved to dismiss her petition, Mr. Woodnick filed a motion for sanctions. In this motion, Mr. Woodnick claimed Laura violated Family Law Rule 26 by filing the establishment petition without medical evidence. Petitioner filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by respondent. Petitioner could not have become pregnant from the limited encounter the parties had and therefore premised this entire action on a fiction. Petitioner violated Rule 26B 1 through 3 in her petition and subsequent filings. And this says motion for sanctions. Immediately following Rule 26 motion, the record becomes confusing and a contradictory mess. Contradictory because your client can't keep her story straight. To begin, on January 24, 2024, the trial court issued an order granting Laura's motion to dismiss. In that dismissal order, affirmed for a second time the next day, the court indicated petitioner advises she is no longer pregnant and has filed motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Yes, and it's not just on Rule 26 sanctions. It is on other rules and other reasons for sanctions that can be issued. Like, I don't know if he thinks that Rule 26 is the only sanction in the entire case of family law, but he thinks that Rule 26 is what everything is about. No, there were other sanctions that were in this case, but David would probably like to use the excuse of, it was before my time, so I don't know about any of those sanctions. Well, it's your job to know the entire case. On February 2nd, 2024, the trial court issued a new order, setting an evidentiary hearing regarding the issue of sanctions and attorney's fees for February 27th, 2024. Shortly before the original hearing date, which was later continued until June 10th, 2024, on February 21st, 2024, the court issued a new order. denying Laura's motion to dismiss, despite the fact the dismissal motion had previously been granted twice a month earlier. The dismissal of the pregnancy part of her wanting the parenting time and child support, that part is dismissed. It was basically approved in one part, denied in another. That's basically what had happened in this thing. Matters that become even more convoluted and confusing. First, on April 3rd, 2024, Clayton moved to withdraw his Rule 26 motion after you threatened him. After more than a month passed without any decision from the court on that request, on May 10th, 2024, Laura filed a motion for judgment on the pleadings and asked the court to deny Clayton's still pending Rule 26 motion as a matter of law. Which, okay, that you should have done, because we didn't have any ruling on that. And so you're like, are we going to get a ruling on this or not? Like, you need to do it. And that is him being a good attorney in this particular scenario. Like, he did his job there. The motion argued that because Clayton failed to comply with the procedural requirements of Rule 26, sanctions were unavailable under Rule 26 or any other authority, such as the court's inherent authority. Great. The motion also renewed Laura's request to dismiss the action since there were no issues for the courts to resolve. But there was. On May 16, 2024, the trial court issued an order granting Clayton's request to withdraw his Rule 26 motion. That order did not, however, resolve Laura's request for judgment on the pleadings, nor did the court mention Laura's renewed request to dismiss her petition. About 2 weeks later, on May 28, 2024, the court issued yet another confusing order, explaining that due to a clerical error, the court had intended to issue ruling on Laura's motion for judgment on the pleadings, but due to the undescribed error, the court's decision was not remitted to the parties. The court discussed various arguments raised by each side on the question of whether Laura could still be sanctioned, given that Clayton's Rule 26 motion was withdrawn and no other sanction motions were pending, but they were. Like, it's just exhausting because he cherry picks. Inexplicably, the court concluded Laura's legal arguments regarding sanctions were moot. Therefore, let the record reflect the court declines to take further action. To recap, at the end of May 2024, Clayton's Rule 26 sanctions motion was withdrawn. The court ruled the issue of sanction was moot and no other motions remained pending. Despite this posture, and with nothing left to decide, the court still held an evidentiary hearing on June 10, 2024. Following a 2-hour hearing on June 18, 2024, the trial court issued a lengthy 19-page decision, which contained findings on the issues of sanctions, paternity, attorney's fees, and costs. Many of these findings are either directly contrary to the admitted evidence or supported by no evidence of any kind. False, David. False. In the end, the court found Laura acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound sonogram physical examination, and in conjunction with a belief she passed tissue in July 2023, the court finds the underlying petition premature at best. Exactly. You're not explaining this July tissue. But we are not here to decide on the case. That's the thing in the appeal. We're not here to be like, the appeals court is not going to reverse it and say Laura was pregnant. Like, that's just not going to happen. Laura was found to be not pregnant by the public and in court. So these appeal courts are not going to do this. This is looking for technicalities and things like that. So he's not going to go and try to explain any more about her pregnancy. In the post-trial ruling, the court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26. The court further noted a separate problem. Clayton's Rule 26 motion was withdrawn. Yeah, but you keep talking about it. Your question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion? She didn't give Rule 26 sanctions. She gave sanctions on other things in law, other ways that she can give them. Without allowing any input from the parties, the court held, despite the withdrawal of Clayton's motion and ignoring his failure to comply with the requirements of Rule 26, and contrary to its prior order, holding the issue of sanctions was moot, and despite the fact that the case had previously been dismissed twice, sanctions could still be awarded sua sponte. This lends credence to the idea that the family court's inherent authority to award sanctions under Arizona Rules Family Law Procedure 26 should not be read to be limited by the course of the case by litigation strategy pursued by parties. This power is there by rule and can be used by the court when necessary and appropriate. Yeah, it can. In addition to awarding sanctions sua sponte under Rule 26, the court also concluded Laura knowingly presented a false claim, knowingly violated court order compelling disclosure or discovery such that an award at attorney fees and cost is appropriate under ARS 25415 and ARS 25324. Exactly. Rule 25, not Rule 26. Rule 25. We know you can count to 26, but you need to have stopped at 25. You read too far. The court later awarded Clayton costs and fees in the amount of $149,219.76 in a judgment entered on August 16, 2024. Correct. C. Post-trial developments. Before the final judgment awarding fees and costs was entered, several critical events occurred. These developments warranted further discussion as they related directly to legal arguments presented in this appeal. First, immediately after the trial ended on June 10th, Laura learned several individuals posted videos on social media claiming the trial judge father, Mr. Harry Howe, personally attended the trial and allegedly spoke with them about the case. Oh my God, a member of the public talked to another member of the public about a public trial. OMG. The audacity of public people. Among other things, these supporters claimed Mr. Howe told them he discussed the case with his daughter. Honorable Judge Julie Matta, and that she printed out case-related documents for him and said, inter ally, Dad, come here. You have got to see this. Yeah, except for she's not the one who prints documents. Usually those are like court clerks and stuff. Second, and far more concerning, after receiving the court's post-trial ruling, Laura immediately noticed one of the most critical factual findings was not based on any evidence admitted at trial. Rather, the key finding appeared to have been copied from a social media post made by an anonymous third party after the trial concluded. Which is funny because he even admitted in one of his videos he did on YouTube that he doesn't know for sure. He is speculating that that's how she found it. He admitted that she could have found it a different way, but this is what he suspects. Well, great. It's not based in fact. You do not have the factual basis to say this. You have suspicions and speculation, and that is not enough to make anything concrete and a factual thing. Like if you caught her on video doing this, or she openly admitted it, that would be some concrete proof. You do, and things can't just be mere speculation and imaginary and things like that in court. They just can't. But he says, specifically in summarizing the trial testimony of Clayton's medical expert, Dr. Samantha Deans, the court made the following findings. She, Dr. Deans, testified that Planned Parenthood does not accept anonymous patients. They don't. You can be anonymous to the public, but you are not anonymous to a facility. And that's any medical facility. You're not an anonymous person there. Patients are required to provide government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care on July 2nd, 2023. The specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans. But as the trial transcript clearly shows, Dr. Deans said no such thing. Okay, so she did say she testified. And maybe she shouldn't have said testified. Maybe it's in writings or something. That could be a misstep. But can you call like their medical findings testimony that's on paper in their expert report, which we've only seen part of? We haven't seen the full report. But as trial okay, so he said, that's not there. Instead, it appears the only basis for the court's finding was social media posts published online after the trial concluded. Yeah, that's not the only conclusion. Immediately upon discovering this extreme serious misconduct by the trial judge, Laura filed several pleadings, including a notice of change of judge for cause, supported by an extensive affidavit of counsel. Laura also moved to vacate judgment, moved for a new trial, and moved to alter and amend judgment. Simultaneously, Laura also reported these matters to the Commission on Judicial Conduct, which opened an investigation which remains ongoing as the date this brief was filed. So he filed a complaint against her for judicial misconduct, basically. On July 18th, 2024, despite having no authority to do so while she was subject to a pending notice of change of judge and before Clayton filed any brief opposing the motion, Judge Mata denied new trial motion and her request for other relief. Several days later, after the apparent act of retaliation, it's not apparent that it's retaliation. It's not. Like, she even withdrew it later. So therefore, the mistake was corrected. Therefore, you don't need to appeal that mistake. Just like Rule 26 was withdrawn. So therefore, if there was a mistake, that mistake has corrected itself in the fact that we're not even going after that anymore. But he thinks everything is still active whether you withdraw it or you don't. Several days later, okay, he said that. So she was reported to the Judicial Conduct Commission on violation of Commission Rule 14, prohibiting acts of retaliation by a judge. This is not retaliation. I don't know if you've had anybody retaliate against you, but this is not what that looks like. But okay. In response to complaint, the commission, Judge Mata, issued a new order withdrawing her prior order. There you go. Null and void. This is not an issue anymore. Claiming she was unaware of the notice of change of judge. That would be suspended the court's authority, even though the notice of change of judge was mentioned on the very first page of the motion for new trial she just denied. Well, because she thought you were requesting it from her. Like, not that somebody else needed to decide it. Kind of like when you're in the middle of a trial and you're like, I need you to recuse yourself. And they're like, yeah, I'm not going to do that. Like, maybe she thought that was kind of what this was. And she's like, the trial already happened, so yeah, we're not changing the judge. On August 13th, 2024, the presiding family court judge, Honorable Rhonda R. Fisk, denied Laura's notice of change of judge. In her order, Judge Fisk recognized that Laura correctly pointed out that Judge Mata's July 17th ruling contains a factual error. She said, even if it does, the transcript from the hearing shows that she did not testify that Planned Parenthood is not open on Sundays. Emphasis added. Yeah, there can be a misstep, but is it harmful? Is that mistake big enough to reverse the entire thing? No, because you can draw all these conclusions on things if we take that completely out. If we're like, you know what? Okay, she got this wrong. But she lied about this, she lied about this, she lied about this. She made up new lies on the stand. Yeah, we still are going to come to the same conclusions, even if we don't know about Planned Parenthood being open, because she lied about 3 different places she went to by the time it ended. Despite this, Judge Fisk concluded the evidence failed to show Judge Mata independently investigated the facts. The court finds Laura relies on mere speculation and suspicion. Yes, mere figments of your imagination, when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. Yeah, like that's just not how this can be concluded. Despite this, Judge Fisk could not explain and did not explain how Judge Mata could have properly found it, because she's not going to speculate either. She's only going to mention things that are factually proven. She's not going to speculate, because what is that going to do? They speculated, so in my reasoning, I'm going to speculate, even though I told them that we're not going to do this because of speculation. Ugh. You're dumb sometimes, mister. Plain manner of close. Since no trial testimony or evidence addressed the issue, Judge Fisk ultimately brushed that concern aside, concluding the question of Planned Parenthood business hours is of little to no importance given the rest of the findings in the July 17th ruling. Exactly what I just said. Even if we take this out, it's still of no importance given all the other lies we have. After Judge Fisk denied Laura's notice change of judge, she authorized Judge Mata to rule on any remaining issues. This resulted in the court granting Clayton's request for fees and costs in a judgment entered on August 19, 2024, and denying all of Laura's post-trial motions for a second time. This timely appeal followed. As explained in Laura's notice of appeal and her amended notice, this court has jurisdiction pursuant to ARS 12-2101, A1, A3, A5A, and needed Baracio Matson in Arizona 1981, and Maldonado versus Aston Co. Appellate case in March of 2024. Statement of issues. Issue 1. As a matter of first impression, when the party files a motion seeking sanctions for an alleged violation of Family Law Rule 26, but that party does not comply with any of the procedural requirements of the rule and later withdraws the motion, may the trial court nevertheless award Rule 26 sanctions sua sponte in a matter that hopefully ignores the procedural and safe harbor requirements of that rule. And assuming sanctions were unavailable under Rule 2016, did the trial court err by sanctioning Laura for Rule 26 violation using its inherent authority or other law? No, because we didn't do them on Rule 26. We did them on Rule 25. So no error. Issue is decided. Issue 2. Did the trial judge commit structural error entitling Laura to a new trial by conducting an independent investigation into the facts? No, because it was not a harmful error. It was harmless. Issue 3. Did the trial court err by awarding sanctions under ARS 25-324 or 25-415 when there was no basis for such an award and no motion for sanctions under the statutes was ever filed. We're going to look at that, or I may have put it in at the beginning of the video instead. We'll see. Issue 4. Did the trial court err by awarding legal fees of $150,000 when alleged misconduct did not cause those fees to be incurred? Yes, it did. Misconduct of both of you. Issue 5. Is Laura entitled to attorney's fees and costs on appeal? No, she is not. We have decided all the things. The end. We don't even need an appellate court to decide. I just decided all 5 issues. Argument. Clayton's failure to comply with the safe harbor requirement of Rule 26 precluded sua sponte sanctions. Citations to record and standard of review. The question of whether the court may sua sponte sanction a litigant for violating Rule 26 in a manner that ignores the procedural requirements of that rule was raised by at least 3 times below. First, in Laura's motion for judgment on the pleadings on that exact issue. Second, in Laura's pretrial statement, contested issues of law. And third, in Laura's post-trial motion for a new trial and other relief. Both substantive motions were denied with no explanation for the trial court's position. They don't have to do that. Sometimes they do, but they don't have to. Most of the times, orders are like denied or granted, and then just a little bit of thing. But like, they don't have to like make a 75-page ruling and tell you why everything. They just don't. Laura's motion for judgment on the pleadings was denied by minute entry order dated May 28, 2024, in which the court held the issue of sanctions was moot. Laura's post-trial motion for a new trial and other relief was denied by minute entry order dated September 6, 2024, which contained no discussion at all. It doesn't have to. When sanctions are challenged purely on factual grounds, an abuse of discretion standard applies. And then he cites some case. We review an award of attorney fees under Rule 11 for abuse of discretion. However, the sanctions are challenged as to their legal basis. Review is de novo. Whether the basis for awarding fees is proper is an issue of law that we review de novo. And then he cites case. Discussion. Summary of Rule 26 requirements. Oh, good God. I am rolling my eyes so hard right now. Rule 26 is simple and clear, dispositive of this appeal, because the correct interpretation of this rule presents a threshold question of law which the court considers de novo. It is worth starting with the basic discussion of how Rule 26 should work, followed by an explanation of how the rule was clearly violated here. I didn't care to learn as much as I know about Rule 26 in Arizona. Like, the fact that we probably could recite Rule 26 ourselves, and if we ever go to law school or Jeopardy asks about Rule 26, we're walking away with all the money. Like, we just know Rule 26. I didn't need to know this much about it. Explaining how it's clearly violated here. Every lawyer is familiar with how Arizona Rules Civil Procedure 11 and its lesser known but substantially identical sibling Family Law Rule 26 function. Yeah, I don't know if every lawyer knows about Arizona's Rules of Civil Procedure, but I mean, maybe they do. I don't know if a Florida attorney does. But sure, every lawyer. Both rules require a party or an attorney to certify each pleading is believed to have at least one minimal factual and legal merit, and that a reasonable inquiry has been performed before the pleading is filed. That part is obvious. Regarding factual allegations, Rule 11/26 have never demanded perfect accuracy. Rather, the rules only require a party to certify the factual contentions have evidentiary support, or if specifically so identified, will likely have an evidentiary support after a reasonable opportunity to further investigate or discovery. That's your problem, David. That's your problem, Owens. She never came up with evidentiary support for her beliefs. She just didn't. And even if she had that belief with a positive P stick, by July, in her bloody tissue, she should have known. Therefore, in August, she should not have filed this. And that's according to Arizona Rules of Family Law Procedure 26B3. In this way, Rules 11 and 26 have always forbidden a party from making knowingly false allegations of fact. But this is a low threshold to clear. Rule 11 sets a low bar, and maybe Rule 11 needs to change. And she might be the reason for the change. It deters baseless findings by requiring a reasonable inquiry that there is some plausible basis for theories alleged, but there was not. And she continued to carry this case on because even in August, when she filed this, she still, till December, didn't say shit. So she had all this shit. And then by December, it's too late because you've done a shit ton of crap on baseless claims with no evidentiary support. There's no plausible basis for her lies. When there is a plausible basis, even a very weak one, supporting litigants' position in position of Civil Rule 11 sanctions is inappropriate. Strom versus United States in Ninth Circuit Court thing in 2011, emphasis added. If a party has any plausible basis to believe a factual allegation may be true, the rule does not allow sanctions simply because that belief is later proven incorrect. A reasonable but mistaken belief does not violate the rule. In this way, Rules 11 and 26 bar knowingly false claims. Yes, she knew they were false. That is what we are saying here. She knew she was lying. But they also provide leeway for parties to bring causes based on what they think is true at the time, even if the belief turns out to be completely wrong. When a pleading is filed in violation of these requirements, Family Law Rule 26, like Civil Rule 11, sets forth a crystal clear three-step process to follow. This process must be followed before sanctions may be requested. Step 1. The party claiming the violation must make a good faith effort to talk directly with alleged violator. In family court, this conversation must satisfy Family Law Rule 9C, which states the discussion must be in person or by telephone and not merely by letter or email. Okay. I want to see Woodnick's response on that. But he really doesn't even have to because he withdrew it. So therefore, Rule 26 is not even a problem here anymore. But if it has to be done in person by telephone and not by a letter or email, but it was also, Woodnick says it was in a court filing. So, I like to hear both sides on that. And maybe Woodnick, withdrew it for that reason. But because he withdrew it, it's not a part of this case anymore. It was not a part of this case in June. Step 2. If the issue is not resolved at step 1, the party claiming the violation must serve the opposing party written notice of alleged violation. So maybe, okay, you know what? Step 1 is not on Woodnick. Step 1 is Clayton and saying, you should drop this case. Like, you know that I didn't impregnate you. You're lying about all this, that. Step 2, Woodnick says he filed it. I'm not going to go back to see if he did, because Rule 26 is a moot point. So it doesn't even matter from the time he withdrew it. Now, if he didn't withdraw it and he was still going forward with it, that part would matter. But he withdrew it. It doesn't matter. Step 3. Or let's continue with step 2. Written notice, alleged violation. Notably, Rule 11 previously required service of a full draft motion for sanctions, but that requirement has been changed to a written notice of the alleged violation, not a motion. After the alleged violator is served with the written notice required in step 2, they have 10 business days which to withdraw and appropriately correct violations. If the violation is corrected or pleading withdrawn within the safe harbor period, sanctions cannot be imposed or even requested. Great. We all know that. B. Clayton did not comply with Rule 26 procedural and safe harbor requirements. As explained, supra, Laura raised the issue of Clayton's non-compliance with Rule 26 multiple times, first in the motion for judgment on the pleadings, and lastly in post-trial motions. Unfortunately, the trial court denied Laura's post-trial motions before Clayton responded. However, Clayton did not provide a helpful response to Laura's motion for judgment on the pleadings. Clayton's argument in the brief shows he knowingly failed to comply with Rule 26 procedural or safe harbor requirements. No, he's not saying that he knowingly failed to comply. That is not what Woodnick and Clayton said at all. To begin, Clayton failed to comply with the Arizona Rules of Family Law Procedure 26C 2A and Rule 9C, which required him to have an in-person or at least telephonic conversation with Laura prior to seeking sanctions. It is undisputed Clayton ignored that requirement because his later filed, then withdrawn Rule 26 motion admitted as much, as did his response to Laura's motion for judgment on the pleadings. Okay. So Clayton didn't do his part, and Woodnick did his. That's not on Woodnick, that's on Clayton. I mean, it is on Woodnick for filing it when if he didn't do step 1, he shouldn't have filed it in the first place. But like I said, none of this matters because it was withdrawn. And I hope the appellate court says this was withdrawn. So why is it even up for? Why are you appealing this when this was not even a part of this ruling? I hope that's what they say to him. Like, what the hell are you wasting all of our times with this crap for? Specifically, in the good faith consultation certification attached to the original motion for sanctions, Clayton's counsel, Mr. Woodnick, never claimed he made any effort to speak directly to Laura, which you don't know that. Like, we don't know that because there were tons of attorneys prior to you and just Laura herself. So you don't know what Clayton did or didn't do. About the specific issue of Rule 26 sanctions before the motion was filed. Instead, Mr. Woodnick's certificate claimed Clayton complied with the conferral requirement because more than 4 months earlier, in August of 2023, he sent two text messages to Laura that indicated he could not be the father of her alleged twin fetuses. These 2 texts said nothing about Rule 26 sanctions and do not satisfy the rule. Okay. Maybe they don't. Mr. Woodnick's good faith certification also claims he had 1 phone conversation with Laura's prior counsel on December 27, 2023, the substance of which is not mentioned in the certificate. But even assuming that the call included a discussion about sanctions, this only further proves Clayton did not meet the other strict requirement of Rule 26. This is because Mr. Woodnick claimed the phone call took place on December 27, 2023, and Clayton's Rule 26 motion was filed on January 3rd, 2024, just 5 business days after the call. Even if the phone conversation met the conferral requirements of Rule 26C2A and was followed by a written notice, Clayton did not provide the 10 business days safe harbor requirement by Rule 26C2B. Okay, so he filed too early. But she could have responded and still dropped it by, listen, I'm just going to even say this is going to be past the 10 days, but January 15th. She could have stopped everything by January 15th, maybe. And the ruling wasn't out on this yet, so she still could have had time. Like, one of her attorneys could have done something during this time period. So maybe he filed it too early. The judge could say, you know what, you filed this too early. It hasn't been 10 days, it's only been 5, even though by the time this ruling is going to come out, it's going to be the 10 business days. I don't know how that works there. If you're an attorney and you know, let me know. The violation is further established by the fact that Clayton's Rule 26 motion did not include an attached copy of the written notice required by Rule 26C2B. See Rule 26C3D, providing a motion for sanctions must attach a copy of the written notice provided by the opposing party under subpart C2B. That notice was not attached to Clayton's motion for one obvious reason. The required written notice was never sent. That's not the obvious reason. Like, to me, if something wasn't attached, I'd be like, did you forget to attach this? Like, you might want to resubmit this, or make sure you submit this and say this is a part of this. Like, that would be my thing, is you forgot to attach something. Not, oh, he must have never sent it. That's just me. In this brief opposing Laura's motion for judgment on the pleadings, Clayton basically admitted these violations but claimed that they were harmless. In short, Clayton argued his violation of the rules were immaterial because Laura should have guessed from other pleadings, such as Clayton's motion to leave to amend, filed December 12, 2023, that Clayton intended to seek sanctions at some point in the future. However, as explained, infra, the law on the issue is 100% clear. Passing threats, settlement demands, and other oblique references to intent to seek sanctions in the future do not satisfy the strict compliance standards of Rule 26. Well, hopefully, if they don't just say, you're wasting our time with this because this motion was withdrawn, so why are you arguing it? Maybe they'll clear it up. Like, they'll clear a lot of things up. And it'll get reformatted. And then they talk about a case, Radcliffe v. Rainbow Construction Co., 9th Circuit, 2001, explaining informal warnings, including threat to seek sanctions made in other pleadings, do not satisfy the strict requirements that a written notice be served on the opposing party prior to filing, emphasis on in original. Barber v. Miller, 9th Circuit, 1998. Clayton's failure to comply with Rule 26 precludes any award of sanctions. No, it doesn't. It does not take away all the sanctions that you can receive in family court. But, okay, sure. Factually, Clayton did not comply with the strict procedural requirements of Family Law Rule 26C2. Even assuming the vague reference to a single phone call with Laura's former counsel on December 27, 2023, included a discussion about Rule 26 and thus satisfied the conferral requirement of Rule 26C2A, which is far from clear. It is undisputed after that call, Clayton did not serve Laura with written notice as required by Rule 26C2B, nor did he wait 10 business days to give Laura an opportunity to withdraw her petition. Instead, Clayton's Rule 26 motion was filed on January 3, 2024, after Laura had already moved to dismiss the action with prejudice on December 28, 2023. The question thus becomes, could the trial court still properly award Rule 26 sanctions? They didn't rule on Rule 26 sanctions. So why are we even being asked this question? Sanctions with the procedural requirement of the rule were not met by law and nevertheless moved to dismiss with prejudice. Surprisingly, published Arizona cases interpreting the safe harbor provision of family law, Rule 26, and even Civil Rule 11 are limited in scope and largely silent as to discrete question. As such, this appears to raise an important matter of this first impression for this court. No, it doesn't, because Rule 26 is moot. Thankfully, this court will not write on a blank slate. There is extensive federal authority on this issue which the court may properly consider. See James Cook and Hobson Incorporated versus Lake Havasu Plumbing and Fire Protection. Appellate Court in 1994. Arizona State's courts consider federal court interpretations of Rule 11. Federal courts faced with the same problem have repeatedly agreed when a party is accused of a Rule 11 violation, but technical requirements of the rule are not strictly followed to the letter, or accused party moves to dismiss, sanctions are unavailable as a matter of law under Rule 11 or any other authority. Okay. That straightforward result was succinctly explained by a recent Maricopa County Superior Court decision, which perfectly summarized and then fully adopted the standards of Rule 11 by citing exclusively to federal case law. Citation remains as in original. Subsection 2 of Arizona Rules of Civil Procedure 11C, the so-called safe harbor provision is intended to give the offering or offending party to the opportunity to withdraw the offending pleading and thereby escape sanctions. A party is not entitled to seek or obtain Rule 11 sanctions if it fails to comply with the safe harbor requirements. And then, cites Lexis, failure to comply with the safe harbor provision precludes any or an award of Rule 11 sanctions. Citing Holgate v. Baldwin, 9th Circuit 2005, we must reverse the award of sanctions when the challenging party failed to comply with the false safe harbor provision, even when underlying filing is frivolous. Moreover, the safe harbor provision of Rule 11 are construed strictly. 9th Circuit 2001, the strict procedural requirement the party must follow when they move for sanctions under Rule 11. Rule 11 sanctions are not available to a party that fails to strictly comply with the requirements of the safe harbor provision. Galler v. Serrano Law Offices, 2020, Arizona. Maricopa Superior Court case, November 23, 2020, emphasis added, denying Rule 11 motion for sanctions where motion was filed without strict compliance with safe harbor provision of rule, and explaining a demand for dismissal and threat to seek sanctions does not transform a settlement demand into Rule 11 compliance notice. And then he cites the Rule 11 threats did not transform settlement letters demanding dismissal of claims into communications that complied with Rule 11 safe harbor provision. And that site, there's a site too that was an unpublished authority, is cited for persuasive value only pursuant to Arizona Civil or Supreme Court ruling 11-1C. This result that sanctions cannot be awarded when the procedural requirements of the rule are not followed or a party moves to voluntarily dismiss is not only required by plain language of the rule, but also by the underlying purpose of the rule, to streamline resolution of the case by encouraging parties to withdraw untenable claims without fear of life-altering consequences. The Ninth Circuit has recognized that core purpose, the provisions are intended to provide a type of safe harbor against motions under Rule 11, in that a party will not be subjected to sanctions on the basis of another party's motion unless, after receiving the motion, it refused to withdraw that position. But it did withdraw the motion. Under the former rule, parties were sometimes reluctant to abandon a questionable contention. Let that be reviewed as evidence of the violation of Rule 11. Under the revision, the timely withdrawal of contention will protect a party against a motion for sanctions. For Rule 11 and Rule 26, And then he cites the Barber v. Miller case again. While our state court decisions have been less clear about the safe harbor's purpose, Arizona courts nevertheless agree Rule 11 and ARS 12-349 share the common purpose of promoting judicial economy by deterring meritless and wasteful litigation. Yeah, well, your client decided to do wasteful and meritless litigations. The purpose of Federal Rule of Civil Procedure 11 is to promote judicial economy, which your client cares nothing about. Rule 11 must be read in light of concerns that will spawn satellite litigation and chill vigorous advocacy. Again, while there is a dearth published state court decision on this issue, federal courts have answered this question repeatedly. Laura explained this at length in her motion for judgment on the pleadings. In that motion, Laura cited several extremely helpful cases, including Westerkamp v. Mueller, Radcliffe v. Rainbow. In the Westerkamp, the defendant gave written notice threatening to seek Rule 11 sanctions based on frivolous pleadings filed by the plaintiff. 8 days later, within the safe harbor period of Rule 11, as Laura did here, even though no valid written notice was ever sent, the plaintiff moved to voluntarily dismiss the case. In Westerkamp, despite the plaintiff's clear attempt to invoke the safe harbor rule of Rule 11 by moving to dismiss before sanctions were sought, the defendant still moved for sanctions. The district court denied the motion. The court held Rule 11 sanctions were unavailable as a matter of law because the plaintiff had every right to invoke the safe harbor without punishment. Defendant's basis for even threatening to seek Rule 11 sanctions based on the alleged frivolous pleading, let alone formally moving for such sanctions, evaporated on March 2, 2023. When plaintiff's counsel offered to stipulate to a dismissal of the entire case with prejudice. That was in Westerkamp, not this one. Because the alleged wrongdoer in Westerkamp, the plaintiff offered to withdraw the complaint and dismiss the action with the safe harbor, and before the defendant moved for Rule 11 sanctions, the court held it was powerless to even consider sanctions. Once plaintiff moved for voluntary dismissal, defendant was precluded from filing the Rule 11 motion. And then add emphasis and cite some other stuff. The underlying purpose of the safe harbor precludes a motion's ability to move for sanctions given the offended pleading had already been withdrawn by a voluntary dismissal. I am sorry, these stupid cars keep going by. It's so annoying. The posture of Westerkamp is not similar to this case. It is identical. Here, like Westerkamp, Laura commenced the proceeding, but then once Clayton's counsel verbally threatened sanctions, Laura immediately moved. No, she did not immediately move to do crap. To dismiss with prejudice. The very next day, on December 28, 2023, before Clayton's Rule 26 motion was filed. As the court held in Westerkamp, the fact Laura moved to withdraw her petition before any motion for sanctions was filed caused the basis for Clayton's motion to evaporate. In short, once Laura invoked safe harbor, her reward was protection against sanctions. The timely withdrawal of a contention will protect a party against a motion for sanctions. Great. No motions. Okay. But they also withdrawed it. Here, the trial court plainly erred when it ignored the law and refused to accept Laura's safe harbor invoking motion to dismiss. But we still have from August to December and all the crap she pulled in that time period that she can be sanctioned on that have nothing to do with a motion. Both errors required reversal of sanctions award and remand with instruction to grant Laura's request to dismiss with prejudice. The conclusion is further supported by another helpful and even more closely analogous case cited by Laura in her motion for judgment on the pleadings, Radcliffe v. Rainbow Construction Co. In that case, like here, the defendant, Rainbow, filed a motion for Rule 11 sanctions without first providing a written pre-motion notice to alleged offender, the plaintiff, Radcliffe. Procedurally, like Westerkamp, Radcliffe is identical to this case. Even though Rainbow failed to follow the requirements of Rule 11, like Clayton, the trial court held sanctions could still be awarded on the court's own initiative. The same legal conclusion applied here. In fact, like Judge Mata did here, the trial court in Radcliffe held literal application of safe harbor provisions was unnecessary in this case. The trial court then awarded $75,000 in sanctions to Rainbow. So they reversed them. So this is where he's saying, instead of awarding Clayton, let's award Laura sanctions for this nonsense. On appeal, the Ninth Circuit reversed. The court explained when a party seeks Rule 11 sanctions, they must comply with the text of the rule. Compliance is mandatory, not optional. When strict compliance does not occur, a trial court cannot gratuitously fix the mistake by converting a defective Rule 11 motion to a sua sponte motion, even though Rule 11 otherwise permits sua sponte sanctions. The Ninth Circuit rejected this attempt to end run around rules safe harbor, thus to ensure the safe harbor was not stripped of all value. The court held a non-compliant Rule 11 motion by a party cannot be converted into a sua sponte motion by the court because doing so would eviscerate the safe harbor function of the rule. We reject Rainbow's argument that the district court's order for sanctions can be interpreted as a Rule 11 motion on the court's own initiative pursuant to Federal Rules Civil Procedure 11C 1B. This provision does not require 20-day advance notice. We reject Rainbow's contention because it was Rainbow, not the court, that initiated the award of sanctions. The district court's discussion of safe harbor provisions in its order concerning sanctions serves to emphasize this point. It would render Rule 11C 1A's safe harbor provision meaningless to permit a party's noncompliance motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Because of Rainbow did not follow the mandatory service procedure of Rule 11C 1A, we reversed the award of sanctions. And then he has emphasis added. Or lots of emphasis added, not just a little bit of emphasis, a lot of emphasis. The Ninth Circuit in Radcliffe got it exactly right. Rule 11 and Family Law Rule 26 are not single-sided coins used only to punish. On the contrary, these rules serve powerful dual functions, acting as both a sword to punishment, bad conduct, but it's also a shield to encourage and reward good behavior by allowing pleadings to be withdrawn without fear of crippling sanctions. That is the whole point of a safe harbor, to provide safety. To be sure, Rule 11 and 26 do not allow courts to punish violators sua sponte when the facts warrant it. And then he cites a case for Appellant 2022 affirming sua sponte sanctions under Rule 11. Courts have noted sua sponte sanctions are extremely rare and will ordinarily be issued only in situations that are akin to a contempt of court. But as the committee comments to the 1993 amendment to Rule 11 make clear, the power requires an order to show cause, which did not occur here. Yeah, we had no show cause hearing. And sua sponte sanctions are payable only to the court, which did not occur here. Furthermore, sua sponte sanctions cannot be imposed when a party moves to voluntarily dismiss before a show cause order is issued. The power of the court to act on its own initiative is retained, but with condition that this be done through a show cause order. This procedure provides the person with notice and an opportunity to respond. The revision provides that a monetary sanction imposed after court-initiated show cause order be limited to a penalty payable to the court, and that it be imposed only if the show cause order is issued before voluntary dismissal. So maybe Owen should pay the court fees and not Clayton fees for her misbehaving. Advisory Committee notes 1993 Amendment of Federal Rules Civil Procedure 11, emphasis added. He cites another case, or another two cases. Adopting committee notes to Rule 11 is providing court cannot impose sua sponte sanctions unless a show cause order was issued before any voluntary dismissal or an agreement of the parties to settle. Here, the trial court never issued any show cause order to Laura. That fact alone precludes sua sponte sanctions. In addition, Laura moved to dismiss her petition with prejudice immediately, literally the very next day. After Clayton's counsel spoke with her counsel, this voluntary dismissal before a show cause order was issued also separately precluded an award of sua sponte sanctions. Either or both of those points are sufficient standing alone to require reversal of the judgment in this case. Because the trial court did not follow the mandatory process for ordering sua sponte sanctions, that means the only remaining option was for Clayton to move for sanctions. But as noted above, Clayton's Rule 26 motion was procedurally defective and later withdrawn. As such, the extent to Laura was sanctioned as a result of Clayton's motion. Reversal is required. Rule 11 sanctions are not appropriate given the safe harbor provision unless an offending party has an opportunity to withdraw the complaint without suffering sanction. Retail flooring dealers versus Boleen something, a 9th Circuit 2003 case. Barber. The purpose of the safe harbor is to give the offending party the opportunity to withdraw the offending pleading and thereby escape sanctions. Emphasis in original. By design, Rules 11 and 26 permit the even most malicious wrongdoer to change his mind and withdraw a disputed pleading without punishment. As the saying goes, that's a feature, not a bug. Yeah, that old saying that everyone knows and says. The safe harbor is offered to all takers, not just innocent ones. A party can take the safe harbor because of a good faith mistake, or a party may withdraw a pleading because they feel the risk of proceeding is just not worth it. In short, the reasons are not relevant. Rule 26 is blind to the wrongdoer's intent or motive. Whatever the reason may be, Rules 11 and 26 allow parties threatened with sanctions to raise the white flag, invoke the safe harbor, and safely withdraw their offending pleadings without fear. Under these facts, and for the same reasons explained by the 9th Circuit in Radcliffe, the District Court in Westerkamp, and the Superior Court in Gallagher v. Serrano, the trial court erred as a matter of law by awarding sanctions to Clayton. Laura's timely motion to dismiss her petition with prejudice terminated Clayton's right to sanctions as a matter of law. Accordingly, this court must reverse the judgment and remand his case with instructions to dismiss the action with prejudice, as should have occurred in response to Laura's motion filed on December 28, 2023. See Holgate v. Baldwin. 9th Circuit 2005. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Are you saying that her filing was frivolous? And before we move on, some sanctions that the judge probably could do is she did not cooperate in the discovery process. She did not hand over all relevant information that she was court ordered to do, so she could have sanctions for that. There was a specific request for attorney's fees that needed to be decided. So that is just the award of attorney's fees. It really wasn't a sanction because that was a separate matter that needed to be decided in bringing this suit. So he can quote all these rules and show cause and everything like that. All she did was award attorney's fees. She did not sanction Owens. The judge didn't. She referred her for prosecution, but she didn't sanction her. She just awarded attorney's fees to Clayton on a myriad of things. So there were no sanctions imposed. If you want to say attorney's fees are sanctions, then whatever, but that's not. It was an issue to be decided, requested by the party. But, of course, he's going to continue on. D. Rules 26 Safe Harbor protects Laura from sanctions under other authority. Assuming the court agrees the award of sanctions under Rule 26 was improper, a different but related question must be addressed. Could Laura still be sanctioned under other authority, such as courts inherit authority? The answer to that question is no. Rule 26 Safe Harbor shields Laura from any punishment arising from her alleged violation of Rule 26. The conclusion is required by several different points of law. First, as noted, the central purpose of Safe Harbor is to ensure a party can withdraw even frivolous pleadings without fear of life-altering punishment. This quid pro benefit the courts and litigants by streamlining litigation and by making it easier for parties to drop claims early without risk of endless satellite litigation, such as occurred here. Indeed, the Ninth Circuit has recognized the value of Rule 11 comes from Safe Harbor, allowing people to withdraw claims safely. Under the former rule, parties were sometimes reluctant to abandon a questionable contention lest they be viewed as evidence of a violation. Rule 11 under the revision. The timely withdrawal of contention will protect a party against a motion for sanctions. Barber. This is also why, as noted above, the Ninth Circuit held in Ratliff that a defective Rule 11 motion cannot be saved by converting it into a sua sponte motion based on trial court's own authority, even though Rule 11 otherwise permits sua sponte sanctions using an OSC process. See Ratliff. In plain English, a safe harbor that provides no safety from punishment is no safe harbor at all. For the reason Rule 26 Safe Harbor must be construed as not only shielding litigants from punishment under 26, but also from punishment under any other authority, to the extent the punishment is based on the same conduct that has allegedly violated Rule 26. That conclusion is required by both the language and intent of Rule 26, but also by the general legal principle, long applied by Arizona courts, that where two rules deal with the same subject, the more specific rule controls. In Marriage of Thorn, Appellate 2014, emphasis added, and some other case laws where two statuses deal with the same subject, the more specific statute controls. And then some other of Appellate 2012, we interpret procedural rules according to the same principles we apply to interpretation of statutes. To be sure, as Clayton correctly argued in his brief opposing Laura's motion for judgment on the pleadings, many other rules statutes generally authorize sanctions for various different types of litigation misconduct. See ROA 111 at EP2 arguing. Title 25 contains at least 3 statutes that expressly instruct the court to award attorneys' fees and sanctions a party in response to unreasonable conduct in the litigation, and citing as examples ARS 25-324, which that one does allow, and I think that's the way the judge said things in her final judgment. She worded things in proportion with 25-324. I was just looking at it, and the way she laid out things, that is exactly, I feel like, what she was awarding attorneys' fees on was the 25-324. But there's also ARS 25-415 and ARS 25-809G. So 3 statutes that you can award those things. But he says, at least on that one point, Clayton is right. Numerous other rules and laws of general application do permit sanctions, including, for instance, ARS 12-349. But when a party claims a specific act violated Rule 26, as Clayton did here in his counsel's very first filing, see ROA 33 at EP2, asking the court sanctions petitioner under Rule 26. The question is whether a specific violation of Rule 26 can also separately be punished under some other rule or law of more general applications, such as ARS 12349 or the other laws mentioned in Clayton's brief, like ARS 25324. So the court decided to order on that. The judge, in my opinion, gave sanctions based on ARS 25324. And the reason I say that is because it says for 25324, a court from time to time, after considering the financial resources of both parties and reasonableness of positions each party has taken throughout the proceedings, may order a party to pay reasonable amount to the other party for costs and expenses of maintaining or defending any proceeding under this chapter or Chapter 4, Article 1 of this title, on request of a party or another court of competent jurisdiction. The court shall make specific finding concerning the proportions of any awards of fees, expenses that are based and considered, or financial resources, and that were based considered of reasonableness of positions. The court may make these findings before, during, or after the issuance of fee award. It also says if the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable costs and attorney's fees to the other party. 1. The petition was not filed in good faith. Judge Mata says she does not believe it was filed in good faith. 2. The petition was not grounded in fact or based on law. Judge Mata stated that. She did not believe that this was grounded in fact or based on law. 3. The petition was filed for improper purpose, such as to harass the other party, to cause unnecessary delay, or to increase the cost of litigation to the other party. Judge Mata cited that because you caused unnecessary delay due to your discovery violations, and even stating a discovery factor at the evidentiary hearing about the Los Angeles Planned Parenthood. You wanted to harass them for not entering your dating contract and increase the cost so maybe they wouldn't fight you. So Judge Mata stated things like this in her final judgment. So she's sanctioned based on this rule. And it says, for the purpose of this section, costs and expenses may include attorney's fees, deposition costs, and other reasonable expenses as the court finds necessary to the full and proper presentation of the action, including any appeal. And he had to set up 2 different depositions because she failed to show up at her first one when the court ordered her to show up. She just chose not to. Now, Corey Keith said she wasn't going to, but they couldn't do that unless the court said, okay, we'll push her deposition to another day. So another unnecessary delay. The court may order all amounts paid directly to the attorney, who may enforce the order in attorney's name with the same force and effect, and in the same manner as if the order had been made on behalf of any party to the action. And in this particular Arizona family law, and then the title 25324, there is no reason to have a show cause hearing at this point either. Now, if you take Rule 26 off the table, can Rule 25 still apply? I think that it can. And she didn't say she wanted to drop the lawsuit. She just said, hey, I'm not pregnant anymore. But she waited 2 months to even say anything because she found out in October. But she was still saying crap up until December. But she also possibly miscarried in July. So, yeah. So it'll be interesting to see what the appeals court has to say. Yeah. Even though Rule 26 was off the table, the judge can still impose Rule 25 sanctions. And sanctions in this case is the attorney's fees. But David says the answer is clearly no. This is so because a violation of Rule 26 must be governed by the terms of Rule 26, including the rule's safe harbor. Rule 26 is highly specific law that addresses exactly the type of conduct Clayton accused Laura of committing, filing a baseless petition. In addition to prescribing exactly that conduct, Rule 26 also sets forth a very specific process for how a violation should be addressed and how the violator may or may not be punished for the violation. Rule 26 could not be more directly applicable to the conduct in question. The rule therefore controls exactly how and when sanctions may be imposed and how and when they may not be. As such, even if other general rules could arguably reach the same conduct, Rule 26 must control and must provide the exclusive remedy for a violation of Rule 26, when a statute creates a right and also creates a remedy for the right created. The remedy thereby given is exclusive. And he cites cases. The rules of civil procedure have the force and effect of a statute. And he said cleaned up. The limitation is implicitly acknowledged by general laws such as ARS 12-349, which permits sanctions for unjustified action, but only in a manner that is consistent with other more specific laws like Rule 26. That limitation is, in fact, expressly written into ARS 12-349, which allows courts to impose sanctions in general, but only except as otherwise provided by and not inconsistent with other statute, emphasis added. Here, putting aside the fact Clayton never actually moved for sanctions under any other authority, 3, after withdrawing his Rules 26 motion, the trial court nevertheless concluded, like the lower court in Ratcliffe, that sanctions could be imposed under other legal authority without the need for a motion, and in a manner that was entirely inconsistent with Rule 26, that holding was plainly wrong as a matter of law. No, he didn't just ask for Rule 26. Go back and read. The holding was wrong because if a party withdraws a pleading in response to a threat to seek Rule 26 sanctions, the safe harbor provision of Rule 26 must provide meaningful protection by allowing the error to be corrected without sanctions under other rules. This safe harbor is needed to ensure the rule functions as intended, incentivizing parties to promptly drop claims when challenged without fear of life-altering punishment as a result. If a party invokes the safe harbor rule of Rule 26, as Laura did here, but is then punished under other authority for exactly the same conduct that violated Rule 26, the safe harbor will literally be stripped of all meaning. This court must firmly and clearly reject that outcome. And so he had a footnote 3 up here, and it says, it is both axiomatic and required by rule that if a party wants relief, they must bring a motion seeking that relief. See Arizona Rules of Family Law Procedure 35A1, explaining a party must request a court order in pending action by motion unless otherwise provided by these rules. B. The trial court committed structural error requiring automatic reversal by performing an independent investigation into the facts. So he's done with Rule 26, thank God. So he says, 1, citations to record and standard of review. Laura raised the issue of structural error in her post-trial motion for new trial, ROA 132. The factual basis for Laura's argument, misconduct by the trial judge, was also raised in her notice of change of judge for cause, ROA 128, and supporting affidavit of counsel, ROA 129. Notice of change of judge was denied by presiding judge on August 13, 2024, ROA 136, and the motion for a new trial was denied by a one-line minute entry order dated September 6, 2024, ROA 140. Record of appeals, I'm guessing. Maybe it's record of appeals exhibits. I don't know. As for these points, the standard of review is de novo. We reviewed both constitutional and structural error claims de novo. We defer to the court's factual finding, but we review de novo its ultimate legal determination. State v. Dayton, Appellate 2024. Discussion. Assuming the court agrees with Laura's interpretation of Rule 26, the inquiry ends. The safe harbor is dispositive of this appeal, and the court need not to consider any other issues other than Laura's request for fees. So he still had to mention Rule 26 once more. He's just saying if you don't decide yes on reversal for the Rule 26, here are some other things that you should also consider. However, if this court chooses to part company with the extensive authority supporting Laura's interpretation of Rule 26, the lower court's judgment still cannot stand. This is because, as explained in Laura's notice of change of judge, ROA 128, the supporting affidavit 129, and Laura's motion for new trial and other relief, ROA 132, clear and irrefutable evidence showed the trial judge committed a structural error resulting in a violation of Laura's constitutional right to due process. This violation occurred when the judge performed an independent and undisclosed investigation into the facts of this case and made post-trial findings based not on the evidence admitted at trial, but rather on social media posts published on the internet after the trial concluded. Although the presiding judge rejected this argument insofar as it was raised in Laura's notice of change of judge, footnote 4. If this court remands for a new trial, which it should not, given the primary argument in relief raised above, Laura should be automatically entitled to a change of judge as a matter of right. See Arizona Rules Family Law Procedure 6F1. For that reason, it is not necessary for this court to separately decide whether the presiding judge erred when she denied Laura's notice change of judge for cause, because that relief is submitted within the structural error arguments raised in Laura's motion for new trial, which this court must review de novo. In other words, remanding for a new trial would automatically entitle Laura to a change of judge as a matter of right anyway, so this court need not decide that separate issue. He says, and although the trial court denied Laura's motion for a new trial, structural error is subject to de novo review. To help summarize the structural error problem, clearly the single most important and most aggressively disputed fact below as the question of whether Laura was actually ever pregnant. Laura claimed that prior to filing the establishment petition, she tested positive for pregnancy 5 times, including the surprise unannounced test given to her by Clayton, which he later confirmed in writing was positive for pregnancy. Indeed, Clayton not only admitted to seeing the positive test, he took a photo of the positive test and emailed it to Laura, ROA 127. See also ROA 129. And then, despite this compelling evidence of pregnancy, Clayton theorized Laura somehow faked the pregnancy as a way of trapping him into a romantic relationship. To support this theory, Clayton retained a medical expert, Dr. Samantha Deans, an OBGYN who previously worked for Planned Parenthood on the East Coast. In her expert report, Dr. Deans never claimed Laura was not pregnant. Instead, Dr. Deans expressed an opinion that women cannot be regarded as clinically pregnant unless the pregnancy is confirmed by ultrasound or other clinical signs of pregnancy. Based on this strange technical definition of clinical pregnancy, Dr. Deans opined because Laura did not provide a verified ultrasound, that meant it was impossible to know whether she was clinically pregnant, implying Laura was actually never pregnant at all, whether in the clinical sense or otherwise. She says, we cannot confirm by any objective data that Ms. Owens had an ongoing viable clinical pregnancy at the time in the last year. Clinical pregnancy is defined as a pregnancy diagnosed by ultrasonic visualization of one or more gestational sacs or definitive clinical signs of pregnancy. In addition to an intrauterine pregnancy. It includes a clinical documented ectopic pregnancy. We have received no verifiable documents of a clinical pregnancy as defined. And he says that is ROA 96. Emphasis added. Thus, according to Clayton, the existence or absence of a verified ultrasound was the single most important evidentiary issue in the case. Just one small problem. Laura could not provide a verified ultrasound. The reason why is the crux of the problem, and it explains why, beyond question, the trial judge committed structural error. Why could she not provide a verified ultrasound? Why? In short, before Laura's petition was filed on August 1st, 2023, Laura provided Clayton with the document she claimed was a sonogram taken in early July 2023 at a facility called Scottsdale Medical Imaging, or SMILE. The SMILE sonogram is found in the record ROA 97. As part of an affidavit, Laura submitted as part of the report of her medical expert, Dr. Medchill, a retired OBGYN physician who was the former chair of the OBGYN department at St. Joseph's Hospital in Phoenix. In her affidavit, Laura admitted to the fact that the SMILE sonogram given was not created at Scottsdale Medical Imaging. Rather, Laura's affidavit explained the SMILE sonogram was taken at Planned Parenthood in California on July 2nd, 2023. ROA 97, affidavit of Laura Owens at 28 through 30, explaining, I did not want Clayton to know where I had gone for the appointment. To conceal that information, I modified the image to change the facility name from Planned Parenthood to SMILE, Scottsdale Medical Imaging. And I also changed the date from July 2nd, 2023 to July 7th, 2023. Putting aside the extreme lapse in judgment that resulted in Laura providing a modified, non-authentic sonogram to Clayton again before this action was filed, Laura steadfast maintained the sonogram was otherwise genuine. On that point, Laura's affidavit was clear. Other than changing the top part of the image to alter the facility name and date, I did not change any other part of the image. This image was taken at a Planned Parenthood in California on July 2nd, 2023. I did not find this image online, and I did not take someone else's image and pretend it was mine. I obviously regret probably this choice. She obviously regrets this, but I made a mistake due to the amount of stress, anxiety, and depression I was experiencing. It's not an excuse to doctor evidence. Clearly, because Clayton's expert opined the only way to confirm a pregnancy was with a sonogram, Laura's testimony on this point was critical. If the sonogram was real, Laura's pregnancy was real. Of course, because Laura admitted to modifying the original sonogram to change the name from Planned Parenthood to SMIL, Clayton understandably did not believe and wanted to independently verify Laura's story. Yeah, because when people lie to you, you kind of want to verify other ways and not take their word. But there was another problem. According to Laura, she did not use her real name for the appointment at Planned Parenthood. As a result, Planned Parenthood could not verify the sonogram was taken there. Owens. If Owens' story was real, David, she knows the name that she used at this Planned Parenthood. So she could call and get that verified sonogram that was taken there and submit it to the court. This is not an excuse. It's a bullshit lie. Oh, because we don't know these things, Planned Parenthood couldn't verify. Well, Owens knows the name she used. So it could be verified. If your client did things with discovery, but she did not cooperate. Another reason you can get sanctions is for not cooperating in discovery. Just stop it. Laura's testimony on these issues was the subject of harsh cross-examination at trial by Clayton's counsel. During the colloquy, Clayton's counsel attempted to argue, using hearsay, that someone from Planned Parenthood claimed Laura Owens' sonogram did not appear to be consistent with ultrasound images generated by their practice. Their practice, meaning a specific office in Mission Viejo, California, which is located in Orange County, California. On this point, the following trial testimony was offered by Miss Arena, Deandra. Question. While you were indicating today that you went to Planned Parenthood under a fake name, this letter actually indicates that you had scheduled an appointment for July 2nd, but you failed to attend. Miss Owens. Correct. So she says she went to go get this sonogram on the 2nd, but she didn't go get it on the 2nd. She failed to attend that. Next question. It also indicates that the ultrasound image that you claimed was from Planned Parenthood was not from Planned Parenthood because it was not consistent with ultrasound images generated by their practice, right? She says not by the one in Mission Viejo. Correct. Miss Owens. These are yes and no questions. This document states that the ultrasound image you have claimed is from Planned Parenthood is not consistent with ultrasound images generated by their practice, right? By that practice, but as they said it, I could have been seen by another different entity. Miss Owens, you are well aware that this request covered all of Orange County and San Bernardino, California. It didn't cover Los Angeles, though. You know who should have given that information? You, Owens. So now you're saying you went to Planned Parenthood in Los Angeles? Yes. So you're telling us you went to Planned Parenthood in Los Angeles on the day of trial today. Yeah. This was the shocking new information at the trial that was everybody was like, what? Yes. Okay. When did you go to Planned Parenthood in Los Angeles? Exactly when I said I went. When was that? July 2nd, 2023. And, they're putting, here's the trial transcript, and you can look at that. To summarize the key events prior to trial, Laura always maintained she went to Planned Parenthood in California on July 2nd, 2023, and had a specific sonogram done at the time. Originally, when asked to identify the specific address of the facility she went to, Laura said she went to a location in Mission Viejo, which is a city in Orange County, California. At trial, when pressed about this claim, Laura changed her testimony and said the location she went to was actually somewhere in Los Angeles, not to Mission Viejo. Why is that address change so important? Because she lied once again to not prove she was pregnant. She's still trying to keep this. Well, y'all still don't have all the discovery, so y'all really don't know. But you could have given that discovery. And why would you not hand over discovery that proves your case? Why would you keep that a secret? If you would have handed that over and it said you were pregnant and it can clear everything up and it would have caused you not to have sanctions, why would you not produce it? I'll tell you why. Because it doesn't exist. David says, here's why. Beknownst to anyone at trial, because the business hours of Planned Parenthood were never disclosed at trial, as the transcript plainly show, after the trial ended, several of Clayton's fans, quote unquote, conducted research that they claimed showed Planned Parenthood locations in Orange County have different office hours than in Los Angeles. Accordingly, to these online sleuths, Planned Parenthood locations in Orange County are open on Sundays, but offices in Los Angeles County are closed on Sundays. This information, if accurate, would appear to directly contradict Laura's claim that she went to Planned Parenthood location in Los Angeles on July 2nd, 2023, because, as the calendar shows, that day was in fact a Sunday. That is not the only thing that shows us that Laura did not go. The fact that she did not prove any medical records came from there also shows she didn't go. But y'all don't even want to talk about that. She won't even put out a Medium article saying, here is my Los Angeles stuff. This proves everything, guys. See, I was telling the truth. She didn't even made a Medium article to lie about that because she knows it would be torn apart. And she doesn't know how to produce that thing that doesn't exist. Again, when understanding this problem, it is essential to consider prior to the day of trial, Laura never said she went to Planned Parenthood in Los Angeles. She always claimed that she went to Mission Viejo location in Orange County, which is open Sunday. This is why Clayton's counsel rightly expressed such surprise and frustration at Laura's change in testimony. No, that is not why. It has nothing to do with the hours. It has to do with the fact that she was told to provide the information of everywhere she was seen for this so-called pregnancy, and she failed to provide that, and she provided a place that she lied about. It has nothing to do with the hours. Nobody's outraged by the fact that of the hours. We're outraged that she didn't disclose pertinent information in discovery, which could or could not have helped prove Clayton's case or Owens' case. Like, it would have helped or hurt Owens or Clayton, one or the other. One would be helped, one would be hurt. That is pertinent information in this, if that is the sonogram that verifies everything. And we can contact them to find out, is this the quality of image you use? Which I guarantee you it's not. Because that's not how sonograms look anymore. I've done a video on what they look like. Prior to that moment, Laura never said anything about visiting a Planned Parenthood location in Los Angeles, but Planned Parenthood locations in Orange County are open on Sunday. So that meant Laura's testimony about going to Planned Parenthood in Mission Viejo on July 2nd, 2023, a Sunday, was a non-issue until the very moment Laura's story changed at trial. Which is why you should grant us this appeal and give Laura attorney's fees, because she is a liar and she needs to be rewarded for her bad behavior. Appellate courts, please give her money, even though she lies and makes a mockery of the judicial system. That was sarcasm. This proves several key points. First, it explains why Dr. Deans was never asked about Planned Parenthood being closed on Sundays in Los Angeles, putting aside the fact that she never claimed to have worked at Planned Parenthood in California and thus lacked personal knowledge of this point. Her only work experience for Planned Parenthood was on the East Coast. Dr. Deans had no reason to discuss the business hours of Planned Parenthood in California for one very simple reason. No one in the courtroom had any idea Los Angeles Planned Parenthood locations have different business hours than those neighboring Orange County, nor did anyone realize or mention Planned Parenthood locations in Los Angeles are closed on Sunday. That information was only discovered by Clayton's supporters, who posted about it on social media after the trial ended. This is why it is so clear the trial judge violated Laura's rights by performing a secret independent investigation into the facts, which included reviewing and adopting as fact statements posted on social media. Like everyone else in court who were obviously to the problem at the time, the trial court judge could not possibly have known about the closed on Sunday issue unless she viewed social media posts after the trial was over, because those posts were the first and only instance where the issue was ever raised. While it is impossible to know exactly what websites the trial judge reviewed, Laura's notice of change of judge offered examples of social media posts made by anonymous third parties on Twitter and websites of undersigned counsel. After the trial was over, where the issue of Planned Parenthood's business hours were emphatically celebrated. Also, you know what was cited in some of the pretrial motions? Gingras's blog. So if she went to look at something that was cited as an exhibit, basically, and a link to Gingras's blog, and while she was doing that and making her judgment, because she was taking everything said at the hearing and all motions that were pretrial under advisement to make her decision, did she err in finding this if she found it on this? She erred in saying who the testimony belonged to, but did she err in making an independent investigation? Or because it was evidence, his blog was evidence, did she just do her due diligence and that stuff just happened to be posted there while she was reviewing the blog, which she was told to view because of your disgusting things you say in it? I wonder. And of course it has the things, Planned Parenthood is closed on Sundays in LA. July 2nd, 2023 was a Sunday. That's right. Laura yet again committed perjury, as always. Laura could not have been served at a Los Angeles Planned Parenthood on July 2nd, 2023. It was closed on Sunday, and all LA Planned Parenthood locations are closed on Sunday. Explain that one. And of course, he never explains that. In light of this evidence, it was plainly wrong for the presiding judge to suggest Laura offered nothing but mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation. To be sure, because Laura asked for an evidentiary hearing on the issue, which the presiding judge denied, it is impossible to knowingly precisely where the trial judge found the online statements claiming that all Planned Parenthood locations in Los Angeles are closed on Sunday. But that does not matter. It is clear with 100% certainty that the source cited by the trial judge, Dr. Deans, never said anything about the business hours of Planned Parenthood in Los Angeles. Given that fact, and given that Clayton's fame-obsessed fans did vociferously post about the issue online hours after the trial ended, the only plausible conclusion in that the trial judge did exactly what Laura claimed. After the trial ended, she went online and performed an undisclosed investigation into the facts, and then she tried to conceal the misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing. In this way, by performing her own investigation into the facts, the trial judge committed structural error, which violated Laura's constitutional right to a fair trial. She made her trial unfair. Just saying. She got a fair trial. She lied so many times that this lie doesn't even matter. Like, the hours of operation don't matter because she lied about where she got it from anyways. The law supporting this point was discussed extensively in Laura's new motion for a new trial. In short, virtually every court that has considered similar facts agrees when a trial judge independently investigates the facts of the case, the conduct constitutes structural error, entitling the affected party to a new trial automatically, without regard to harmless error analysis. The Arizona Supreme Court embraces the same standard. In cases involving trial error, we consider whether the error so assessed was harmless beyond a reasonable doubt. If so, we uphold the verdict entered. Exactly. This was a harmless error. In a limited number of cases, however, structural error occurs. In such instances, we automatically reverse the guilty verdict entered. Well, this is not a guilty verdict, first of all. This is not a criminal trial. Unlike trial errors, structural errors deprive defendants of basic protections without which a trial cannot reliably serve its functions as vehicle for determination of guilt or innocence. Well, this is not a guilt or innocence case, and no punishment may be regarded as fundamentally fair. Presumably due to the high ethical standards of most Arizona jurors, comparable instance of a judge conducting an undisclosed investigation into the facts of a case and then adopting findings based on that investigation, as occurred here, are essentially non-existent. However, courts in other states applying the same constitutional standards are in unanimous agreement. It is structural error requiring automatic reversal when a judge independently investigates the facts of a case. This is so because the bedrock due process requirement of fairness requires that conclusions reached by the other trier of fact be based upon the facts and evidence and prohibits the trier of fact from reaching conclusions based on evidence sought or obtained beyond the adduced in court. Thus, if a judge, especially in a bench trial, personally investigates the facts or disputes or makes findings based on his or her own independent research or knowledge rather than based on evidence admitted at trial, this conduct is a per se violation of the due process clause, which constitutes structural, not harmless error. First, the judge sitting as a finder of fact indicated by her comment during Worthy's testimony that she believed, based on the facts not in evidence, that Worthy's statements about the date of Page's deaths were likely false. The comments disregarded the judge's duty as a finder of fact to make factual determinations solely on the basis of evidence in the record. Second, the judge independently investigated a fact not introduced into evidence, violating her obligation as a finder of fact to refrain from seeking or obtaining evidence outside the presented by the parties during the trial. She cites the case. Sixth Circuit Court of Appeals stated, unquestionably, it would be impermissible for a trial judge to deliberately set about gathering outside facts of the record in a bench trial which they were presiding. And he cites the case with emphasis added, cleaned up, and reversing defendant's conviction and ordering a new trial upon finding trial judge conduct improper ex parte investigation into the facts. This was a conviction. It's a little bit different in a criminal court when somebody is basically losing their life over possibly killing somebody and somebody having to pay attorney's fees for lying. Criminal court and civil court and even family court are not the same. They're just not. They're different. But criminal and civil, way different. Ordering a new trial where the judge in the bench trial considered facts not admitted into evidence in reaching his conclusion. Of course, judges are permitted to consider facts outside the record if those facts are proper subjects of judicial notice. However, as the American Bar Association has explained, the business hours of Planned Parenthood in July 2023 would not fall within that expectation or exception. See American Bar Association Original Opinion 478. Independent factual research by judge via the internet, December 8, 2017, explaining a judge may not use an internet search to determine hours of operation of a business, nor are business hours properly subject to judicial notice. This internet search violates Rule 2.9c of the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail. When a judge ignores the most basic principles and conducts an independent investigation, results a structural error requesting automatic reversal. This is true regardless of whether the ex parte evidence found by the judge is true, false, or completely accurate. We conclude that Dorsey was deprived the basic protection of an impartial judge and finder of fact when the judge independently investigated a factual assertion made by a key defense witness and revealed the results of her investigation to counsel. This interpretation constituted a structural error, which precludes harmless error analysis and requires that we reverse without regard to the evidence in Dorsey's particular case. And then he cites the Dorsey case from 1991. Okay, then we have reversing in a family law case. Trial court ordered vacating stalking orders where the judge investigated facts independently. An improper ex parte investigation by the district court is prejudicial when it bases its ruling, even in part, on the investigation and a fact that is inferred from that investigation. Maybe she saw that, but taking that part out, it wasn't a basis for her ruling. She mentioned it, so maybe it was, but everything else still, keeps her order the way it should be. Here we have reversing conviction and ordering a new trial before a different judge, where the district court made an important finding of fact that is not based on any evidence introduced in trial. Rather, it is based on facts otherwise known or believed by the district court judge. The district court's error is structural error that requires automatic reversal of the conviction and a new trial. Once again, you're citing criminal case in a civil family law case. Appellate courts don't want to hear about your criminal law when this is not a criminal case. It should be a criminal case, but it's not. Although the presiding judge attempted to minimize the misconduct of her colleague by suggesting the singular fact finding regarding the business hours of Planned Parenthood is of little to no importance given the rest of the findings in the July 17th Sick ruling, that conclusion applied the wrong legal standard. It was also factually incorrect given the issue of Planned Parenthood hours was vitally important. It wasn't vitally important because she still lied and didn't produce any evidence from that when she was asked to. She has a discovery violation automatically by doing this. This is so because harmless error analysis does not apply to structural error. See State versus Valverde, an Arizona case in 2009, explaining if structural error exists, reversal is required regardless whether the defendant objected in superior court and without the need for any separate showing of resulting prejudice. Cites some more case. Structural errors create defects in the trial mechanisms itself and affect the entire conduct of the trial from beginning to end, damaging the framework within the trial proceedings. Ellipsis in original, and cites a case. For those reasons, although this court should not force the parties to waste any further time or resources on a retrial because the safe harbor issue discussed above is dispositive, the lower court's judgment must be reversed because the trial judge committed structural error which violated Laura's constitutional right to a fair trial. C. The award of fees and sanctions under ARS 25-324 and or 25-415 was plainly erroneous. So once again, the award of fees and sanctions, he's even stating, they were given under Rule 25-324 or another one, not Rule 26 or Rule 11. Number 1, citations to the record and standard of review. If the court reverses for either or both of the set forth above, it need not reach any other arguments. However, Laura raised the trial court's erroneous award of sanctions under ARS 25-324 and other authority in her motion for new trial and other relief. ROA 132, as noted above, the motion for new trial was denied by one-line minute entry order dated September 6, 2024. As also noted above, when sanctions are challenged on factual grounds, abuse of discretion applies. However, the legal basis is challenged review is de novo now. Whether the basis for awarding the fees is proper is an issue of law that we review de novo. to the discussion. In addition to sanctioning Laura under Rule 26, the trial court also cited ARS 25-324 as a separate basis for the fee award. Yeah, because she had the right to do them under these things. However, as Laura explained in her motion for a new trial, by its own terms, ARS 25-324 does not apply to paternity proceedings. It only applies to the costs and expenses maintaining or defending any proceeding under this Chapter 3 or Chapter 4, Article 1 of the title. By definition, this does not include statutory paternity proceedings under ARS Title 25, Chapter 6. It can. I don't know why you think it doesn't. From what I was reading, it absolutely does. But I'm not a lawyer, so don't take my word at that, maybe. Do your own research. That motion further explained that although the correct statute, ARS 25-809G, does permit fees to be awarded where a party has engaged in unreasonable litigation conduct, and such conduct necessarily caused by other parties to incur fees and costs, the facts here could not support such an award because once again, Laura attempted to invoke the safe harbor provisions of Rule 26 by moving to dismiss her petition before the vast majority of Clayton's legal fees were incurred and before any fees were actually necessary. Again, it was undisputed that both Clayton and Laura were pro se from the time of the original petition was filed on August 1st, 2023, until Clayton retained counsel, who appeared in mid-December 2023. At that time, Laura moved to dismiss December 28, 2023. Laura had miscarried over a month earlier, and the case was set for administrative dismissal. Laura did nothing whatsoever to keep the case active once she learned she was no longer pregnant. While perhaps it would have been preferable for Laura to notify the court of her intent to dismiss sooner, the delay did not cause Clayton to incur legal fees. The case was already scheduled for dismissal due to the lack of activity before Clayton's counsel even appeared. If Clayton's counsel had done nothing, the case would have been dismissed without a single dollar of fees incurred by either side. The only reason that did not occur was Clayton's decision to file Rule 26 motion for sanctions, which he later withdrew. For that reason, there was no factual or legal basis for an award of attorney's fees under ARS 809G, because even assuming arguendo, the original filings of the petition was unreasonable, that act did not cause any fees to be incurred, since the action was scheduled for dismissal before Clayton even retained counsel. Similarly, the trial court found sanctions were justified because Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery, such as an award of attorney's fees and costs, is appropriate under ARS 25-414. That holding was also incorrect as a matter of law and must be reversed. But it also could be 25-324. This is so because its own terms, ARS 25-415, permits sanctions when a party has presented a false claim under sections 25-403, 25-403.3, or 25-403.4, with knowledge that the claim was false. But none of those statutory provisions applied here. ARS 25-403 involves issues such as legal decision-making and parenting time. ARS 25-403.03 addresses issues of domestic violence, while ARS 25-403.04 permits a court to consider that a parent has abused drugs or alcohol or has been convicted of a drug offense, making custody determinations. Well, nobody was citing any drug and alcohol crap. You just knowingly filed this false lawsuit. Knowingly. Malicious. Reckless disregard for the truth and knowingly false information was served up in this suit that she filed. Clearly, there was no basis for the court to conclude that Laura knowingly presented a false claim under ARS 25-403. And the other 403 numbers, yes, she knowingly presented a false claim. She falsely lied a bunch of times in October, prior to December. And Clayton hired Deandra to come in on the, well, that was not this case. Well, they did roll that into this case, I think. The order of harassment. He still had to have legal fees and discovery. That was a different case, technically. I don't know. Of course, ARS 25415 also permits sanctions if a party has violated a court order compelling disclosure or discovery. But here, there was literally no basis for the court to hold that Laura violated any order. I'm sorry, do what? She admitted to not cooperating in discovery basically at trial when she said Los Angeles. So, yeah. But he says, specifically in the proceedings below, the court did not grant one motion to compel, resulting in a single disclosure order. That order required Laura to provide 5 categories of information, but Laura fully complied with that order by disclosing all required information. No, she did not. She did not put Los Angeles on her HIPAA thing that the judge made her sign in front of her. So that's a lie. But, oh, that's before David's time, so we have to just forget that. Indeed, the point is demonstrated by the fact that Clayton never brought up any motion seeking sanctions under ARS 25415. Had he done so, naturally, Laura would have responded with evidence proving she fully complied with every aspect of the court's discovery order. But Laura had no opportunity to offer that explanation. She has every opportunity to prove her case here, and she didn't. And she withheld evidence, or she lied about evidence existing that didn't actually exist. It's still a discovery violation, plain and simple. Because no motion was ever filed seeking sanctions under ARS 25415 or any other authority cited in the trial court's June 17th hearing. That fact alone warrants reversal of the trial court's judgment to the extent it found sanctions were proper under ARS 25324, ARS 25415, or ARS 25809G. No, it doesn't. D. The awards of fees was erroneous because the fees incurred were not necessary nor reasonable. Citations to record and standard of review. Here, after Clayton applied for fees and costs, Laura objected. Among other things, Laura noted an award of fees was factually improper for one simple reason, because Clayton did not incur any fees prior to the time the case was scheduled for administrative dismissal. Laura also noted the amount of fees was patently unreasonable in light of the controlling standard. ER 1.5. The trial court never expressly ruled on Laura's objection, but it was implicitly denied when the court granted Clayton's request for fees. As noted several times above, when a fee award is challenged on factual grounds, an abuse of discretion standard applies. A court abuses its discretion when its discretion is manifestly unreasonable or exercising on untenable ground or in untenable reasons. Well, I don't think she did any of that. She had a lot of reasons to grant those attorney's fees. One, for wasting everybody's time and all the money that he had to spend chasing down things, and he still didn't get to chase down one piece of discovery because she failed to say something about it. Discussion. Again, because the appeal may be fully resolved on other grounds, the court need not address this point. However, it is worth the brief explaining. I'm sorry, I did not read that correctly. However, it is worth briefly explaining that even if Clayton's position was correct, and even if the trial court had the ability to sanction Laura under Rule 26 or any other legal authority, that does not mean the award of nearly $150,000 in fees was appropriate here. The simple fact remains that even if Clayton's factual allegations are true, and even if Laura was never pregnant, which she obviously disputes as vigorously as possible, the filing of Laura's petition did not cause Clayton to incur $150,000 in fees and costs. This is so because both parties were pro se during the entire period between the initial filing of the petition on August 1st, 2023, and the time when Laura learned she miscarried in November of 2023. Had Clayton's counsel simply picked up the phone in mid-December and asked Laura about her intentions as a family law Rule 9C required him to do, she would have informed him that she was no longer pregnant and that there was nothing further to litigate. Again, at that point, Clayton's fees were literally $0. No, because his name was out there. So if he can do that by this and not have to file a different case against her, let's try to get it done on this one. But maybe he should have filed a different case and done it that way. But that is not what happened here. So I will be happy for the appeals court to at least clarify on certain aspects of the law that maybe we don't know. Whatever the appeal decision is, it will at least clarify some of these things. And that needs some clarifying for future cases, just from a legal standpoint. I hope it's not reversed. I hope there's not a technicality. I don't want Laura to get awarded for bad behavior. But I would like to see some clarification on, is Rule 26 the all-empowering sanction rule? And that if 26 is not the thing and she's like, oh, I would have withdrawn it, can you not apply other things just because of Rule 26? Like, why do you even have other rules if Rule 26 is the all-encompassing rule? That is one of my questions. There is simply no legal authority of any kind to support what occurred here. Clayton asked the trial court to force Laura to involuntarily continue litigating this matter, and he then asked the court to sanction her for continuing to litigate this matter. The trial court's decision to permit this sham was clearly an abuse of discretion in every sense of the term. For that reason, even if all of Laura's other arguments are rejected, this court should still reverse the fee award in its entirety on the basis the trial court abused its discretion in both the legal and factual basis for the award. E. Laura is entitled to fees on appeal. Pursuant to Arizona Rules of Civil Procedure, Appellate Procedure 21A, Laura gives notice that she seeks an award of attorney's fees incurred in this appeal pursuant to ARS 25809G, permitting in any paternity proceeding award of attorney's fees, deposition costs, appellate costs, and other reasonable expenses the court determines were necessary. In the proceedings below, Clayton committed multiple violations of rules of family law procedure, including but not limited to filing a Rule 26 motion for sanctions without complying with the procedural prerequisites of the rule. Of course, Clayton later withdrew his 26 motion after Laura's counsel threatened to seek sanctions under Rule 26 on the basis Clayton's actions were violated that rule. Because Clayton invoked the safe harbor of Rule 26, Laura is not requesting sanctions against him under that rule. Yeah, he revoked this thing. He said, okay, we'll take 26 off the table. We'll leave this other shit. Nevertheless, Clayton's other conduct is more than sufficient to entitle Laura to fees under ARS 25809G. Clayton continued to aggressively litigate this paternity establishment action despite knowing Laura was no longer pregnant. That fact alone was and is sufficiently unreasonable to entitle Laura to her fees on his appeal. God, I hope not. Conclusion. For the reasons stated above, Laura respectfully asks this court to reverse the trial court's judgments in its entirety and remand this matter with instructions to dismiss the case with prejudice. In the alternative, Laura requests an order reversing the judgment and remanding this matter for a new trial. In either case, Laura also requests an award of fees and costs incurred in this appeal. So she wants her appeal fees and costs. And Gingras signs it November 14th, 2024. The certificate of compliance and the certificate of service to Woodnick and all of them. And there it is. That is Owens' appeal brief. And now we will just wait for Clayton and Woodnick's response, which is due around Christmas. So, here in the next couple of weeks, we might see that. So subscribe, like, and comment down below your thoughts, and I will see you in the next one. Bye.